Judge Joe Brown's all-new barbecue sauce and seasoning. Justice in the form of flavor.
Law firms will take this as a retainer.
What? It must be a law firm where they hungry as hell. Now you gonna help me with this parole I'm dealing with?
Judge Joe Brown's all-new barbecue sauce and seasoning. Justice in the form of flavor. With one taste of our premium blends of all-natural ingredients, herbs, and spices, you'll fall in love with meat all over again. Judge Joe Brown's all-natural barbecue sauce collection is made up of 2 zesty flavors, original and spicy. There's only one way to bring order back to barbecuing. Just add Judge Joe Brown's all-natural barbecue sauce and seasoning, and you be the judge.
Well, I want to move on to Jay-Z, right?
Okay, yeah, let's do that.
So, breaking news, this came down yesterday. Jay-Z is named in a civil suit alleging we're just going to use R for that word, 4-letter, of a 13-year-old in 2000. A new lawsuit accuses Jay-Z and Sean Diddy Combs of R-ing a 13-year-old girl at a party following the 2000 MTV VMAs. The accuser, Jane Doe, claims she was drugged and assaulted by both men at a house party. The lawsuit, originally filed in October against Combs, was refiled Sunday to include Jay-Z. Combs already faces federal charges, including sex trafficking, while Jay-Z team has yet to comment. Doe is seeking damages under New York's Gender Motivated Violence Protection Act. Now, Jay-Z did respond yesterday.
My reaction to that is the law has gotten ridiculously out of hand here. If you take all of the states in the United States of America for a personal injury or a personal harm or wrong, there's generally either a 1, 2, or very rarely a 3-year statute of limitations. In other words, if somebody says, okay, the state may be charging this guy with murder, is a criminal charge, we, the family, can charge this guy with a civil charge of homicide. We get 1 year or 2 years, maybe 3. But somebody pinches a booty or a titty, they get 50 years to file their lawsuit. It's like, excuse me, the squeeze is not as serious in the scheme of things when it comes to an orderly society as an outright homicide. So what is it about this where you have skewed the law for these things to happen? Now, this woman, if she was 13, 24 years ago, is now 37 years old. So you mean to tell me that by now, this has gone on 13 years old? What the devil's happening? Didn't your mama get upset about it? Your father get upset about it? About where were you? And you didn't deal with it. What's happening 24 years ago is a lot of time when it comes to witnesses. You can't put a trial on. And there are all sorts of other things, evidentiary-wise, when it comes to the proof that a person is able to generate and put on in a courtroom that is very much stacked against the defendant. I have watched in a trial while some horrible stuff goes on. One of the worst I've ever seen didn't have anything to do with a statute of limitations. It was a criminal charge. This person was indicted for an especially aggravated charge of R. Mm-hmm. And what saved him was a very interesting and absolute save. There was a lot of confusion about when this has supposedly occurred, and when it was nailed down, fortunately, 2 of the defendant's buddies were still in the United States Army, and they got his records sent over by a master sergeant. And when they got there, the state wanted to object to them being allowed to put on their proof. I let them do it, and it turned out that the defendant was in a tank turret, an M60 tank turret in Germany, right there between West Germany and East Germany at the Fulda Gap, guarding the West from a tank incursion coming out of the Ukraine. And this was supposed to have been 1989 when this occurred. The trial was in 1991. And this man was in a tank turret. He was a tank commander, and he had no leave, and he was verified to be there with the division records, regimental records, and the battalion records, operating a tank on a full-blown NATO exercise at the time this crime was supposed to be committed. So he was 9,000 miles away with no ability to get there, and he was there the day before in the field, bivouac. He commanded the tank. The tank got commemorated or cited for outstanding excellence in the activity, and he was there for the next 3 days, so it would have been possible for him. The other thing that I found interesting about it was we thought the case was going to be dismissed because it's set for trial for the third time, and the state is looking for its victim, and did realize they were looking at the victim, but they thought the victim was an ugly looking guy. So he had been sitting there for the last 2-3 trial sittings, and she'd been sitting there in the witness room, and nobody even recognized it for being a woman.
What is your point?
The point is that sometimes when you get these boutique crimes, you get them out of hand and they work an injustice if you don't have a very sharp defense lawyer, which this guy couldn't afford. And the only reason he got me was because the public defender's office had a conflict and the guy couldn't hire a private attorney.
Mm-hmm.
He got me as a judge, and I wound up giving him.
What does that have to do with the Jay-Z situation?
Well, in other words, it's just this thing that we had developed at that point, where there was a particular preference given to the prosecutability of certain kind of crimes versus others. So when you started slanting justice, saying, we want to make it easier to prosecute this kind of crime with reduced standards of proof, you start running into instances of misjustice. If there had not been a judge like me presiding over the case to say, to hell with you, I'm letting this proof in, this man probably would have been convicted and his life ruined. As it was an innocent man who was on trial. He wasn't even in the United States of America. This was supposed to be the R word, especially aggravated, that occurred in Memphis, Tennessee, at a time when the defendant was in a tank turret in Germany. So, in other words, what it was is everybody was bending over backwards to be sensitive to the plaintiff.
I need to bring it back to New York and present.
So I am. In other words, the whole point is in other words, you institute a civil case almost a quarter century after it is alleged to have happened, when in most of the United States, even if it was a homicide, you wouldn't have but 1, 2, or at most 3 years to bring the lawsuit.
So let me read this. The allegations against the billionaire rapper and hip hop mogul, Mr. Combs, who is facing federal sex trafficking and racketeering charges and at least 30 lawsuits accusing him of sexual misconduct. One of those lawsuits, filed in October, accused Mr. Combs and an anonymous celebrity of R-ing the teen at an after party following the MTV Music Awards in 2000. On Sunday, the plaintiff amended the lawsuit to name Jay-Z as the other celebrity, asserting in court papers that he and Mr. Combs took turns R-ing her after she arrived at a party and drank part of a drink that made her feel woozy and lightheaded. Jay-Z called the claims idiotic and said that he came from a world where we protect children. Mr. Combs has denied all allegations of sexual assault and misconduct and has pleaded not guilty to the criminal charges. Now, also what happened an hour ago, not only did he issue his statement, his lawyers fired back in a court filing Monday today, after he and Sean Diddy Combs were accused of arming a 13-year-old at an after party. Carter filed a motion Monday to deny the plaintiff's request to remain anonymous, calling for either her identity to be disclosed or the suit to be dismissed. Now, she is being represented, the so-called victim is being represented by Texas attorney Tony Busby of conducting, and Jay-Z is accusing him of conducting an extortionate campaign. This is the same guy who created this hotline for people to call who felt at one point that they were victimized by Diddy, and they had over 100 people filing a complaint against Sean Combs. So he's a personal injury lawyer out of Houston. He's filed at least 20 lawsuits against Mr. Combs and used a phone hotline, Instagram, and news conference to find clients. So is he the real deal, or is he just another like a Ben Crump, but on this side of the law, you know?
What you have is a growing trend in law to convert it from a profession to a business. And I've noticed that the best businessmen, when it comes to practice of law, are not necessarily the best professionals when it comes to the practice. It all depends on motivation.
Now,
sometimes they are. I'll give you a quick anecdote. For several years back in the 90s, I was a guest lecturer at Yale Law School on the subject of representing.
Another long story.
No, there's not another one, but people need to understand these things. And it was a week-long seminar or series of lectures on poverty representation or representation of indigent criminal defendants. I came up with a long reading list that would get people up to speed on what the subject was about. And the first time I did it at Yale and sent the list forward, I was surprised when I discovered that damn near every one of the 40 plus students who had signed up for the classes had read the material in a very short period of time. And it had been my experience that most students might brush over the stuff and just take a look at it. And that's it. They'd actually read it in detail and could discuss it at length. So I'm asking this guy whose family opened up a law firm 180 years ago, and I'm saying, well, why are you, considering the fees that your firm charges, are you interested in poverty law representation when it comes to criminal offenses? He said, well, our law firm believes in giving back to the community, so we do pro bono work. So I'm going to be the best damn pro bono lawyer I can be. So I said, whoa, that's impressive professionalism. And then I'd been doing this same series at other law schools that were lesser, and all they were relying upon was my lectures, and nobody read anything at most of the law schools except some of the very top ones. So I noted that the people that got into the top caliber law schools tended to do the extra work, and the ones that were, well, essentially mediocre students didn't do the stuff, didn't even try to. And that, I think, has got something to do with the practice of law. It's an opportunity to make a lot of money fairly quickly, and it causes the public to suffer. The fees are extraordinarily high. They're way out of proportion. The work that is done is very little in proportion to what ought to be done. The competence is low. And you have both judges, prosecutors, and defense lawyers and plaintiff lawyers who have a lot of clients, make a lot of money, and they're essentially rookies or amateurs because they have not done what it takes to really learn the profession, particularly when it comes to lack of trial experience.
Which is why they try to go for the civil case till they could get money and get a quick settlement.
Yeah, because on a criminal case, there's always this remedy called post-conviction relief, which is outside of the appeal and separate. Somebody can come in, and one of the most frequent two types of successful complaints is one, incompetence of counsel, or two, ineffective assistance of counsel.
Mm-hmm. Well, I want to stick here on Jay-Z for a little bit longer. It says many of the lawsuits did not survive because the plaintiffs declined to be named. However, in this case, the judge said that then 13-year-old showed significant cause to continue anonymously. What does that mean? What can you show how old is she? 37 now?
37. So what's the legitimacy for that?
It doesn't say, but apparently a judge felt as though she has significant cause to continue to be anonymous and not give up her identity.
Well, look at New York.
Right.
Yeah.
So I have a question. So this is a civil suit, but can now the feds that is prosecuting Diddy with this civil suit adding Jay-Z, can the feds add Jay-Z onto those criminal charges that they're charging Sean Diddy Combs with?
Well, they did something like that. They only charged Diddy with 3 counts of indictment. But instead of it taking one long page or at most 2 pages, as would be typical for a 3-count Mann Act indictment in the federal system, which I'm quite familiar with, they took 14 pages and they put in all sorts of salacious things that have absolutely nothing to do with the criminal charges where they're trying to influence the jury. That's the same federal prosecutor who charged Mayor Adams with 4 indictment counts, but took 57 pages to do it, including a lot of pictures of upscale hotels and hotel rooms trying to negatively influence the public for public relations purposes. See, there is this change. First thing Trump needs to do, since it's a high profile location, is quickly make one of his first appointments for U.S. attorney somebody else rather than the clown that they have there in New York City right now, who is a disgrace.
He's resigning this week. This is his last week.
Good.
So, yeah.
Get him the hell out of there.
But as for the purpose of Jay-Z, when you have this civil case, this particular civil case has nothing to do with the federal case, but can the feds use that to add?
No, they can't. Okay. Because there's a statute of limitations that's long run on the civil matter, and its only thing they have is the 14 section, which deals with Mann Act violations, which we call them in the profession, and that's transporting females across state lines for illicit purposes.
Can the federal government create charges for Jay-Z, separate charges?
That I'm saying they don't have a series of charges, criminal charges that would embrace that.
Have nothing to charge him with.
That's right. Nothing federal.
But can they use or take something or go further deeper with this civil lawsuit? Like,
they might try to bring the civil suit in to inflame prospective jurors, which they do. That's what you looked at with this whole Trump thing, whether it was Fannie or whether it was Smith or whether it was Bragg or whether it was Tish. They were trying to use the press to inflame the public. So the public, 34 convictions. No, all of them are bullshit. They're going nowhere. This is just abuse of law. So the real case is you saw in real time people who abused the law, criminally abused the law. This was not what was intended. This is why we have the Bill of Rights and why the 14th Amendment amongst other things it does, implies that due process, or specifically applies due process to the states, whereas before it was only under the Fifth Amendment to the federal government.
Now, Jay-Z is saying, no, sir, it had the opposite effect. It made me want to expose you for the fraud you are in a very public fashion. So no, I will not give you one red cent. That's what he said in his statement to this attorney, Tony Busby. And he should not. And, you know, when we look, remember it was the look back law that New York allowed for 2 years. It's a chain effect to where with that law, the lawyers, they all got together and said, listen, we're not going to take cases unless the person that's being accused is making $500,000 or more, because there's no profit if he's a regular man making $60K a year. So, so where's the justice, right? So, and it's all civil, it's all about money. It was all about money and not about actual justice. Because I would like to ask a woman, if you are not fighting for criminal charges, but you take money, how is that money making your situation, what so-called happened to you, better?
And where were you that night anyway? And how is it that your parents did not jump you for being gone all night? And then what were you trying to do? And who were you hanging out with to be at the party in the first place?
Which is probably why she wants to stay anonymous, because if we see a picture of her at 13, she probably looks like a 13-year-old. So then you have to ask yourself, they knew you were a minor. Why were you so-called there? Were you even there? And then two, if it was an after party, it had to be camera somewhere, but I guess before, you know, it's a reason why she wants to stay anonymous. And it's not because she wants her privacy, because when you accuse someone, especially a high profile, accusing someone and with that accusation, you have no more privacy. So why not show your face? Why not give us your name?
And then it may be somebody might say, oh, I was there. No, how did she get out of the house dressed like that?
Right. Where were you?
In a wig and, you know, a weave and no telling what. And see, the R word for somebody that age, I think it should be the R word for somebody 13, because they can't consent. But, you know, find it interesting. The same people that are saying she couldn't consent at 13 are saying it's all right for a boy to cut his dick off, or a girl at the same age to cut her tits off, you know.
So here's another thing.
Because
how can Jay-Z defend himself when he don't even know this person's name, her identity, and okay, what is the evidence?
How are you gonna go get a detective out there or a detective crew? Who are we looking for?
And he has his right to hire an investigator.
Mm-hmm.
So is this attorney is he hoping he'd be so scared with all the heat on Sean Combs? Sean Combs, that Sean Carter would just write us a check to make it all go away. And first of all, Sean Combs made the mistake writing that girl that $30 million check last year, because as soon as he wrote the check, then all this other accusation started coming down. Jay-Z saw that. He's seen that. He's not going to give nobody nothing, guilty or not. And he's not guilty because he hasn't been proven guilty.
Well, see here, let me give you one other little thing. I have gone to law schools and lectured over the last 25 years. And when I went to law school, we got taught, don't take the case if there is not a meritorious issue that can be resolved at trial.
What does that mean?
In other words, what's going to happen if you go in front of a jury? Is there a likelihood of success?
Mm-hmm.
Remember the thing about Joe Biden did everything you accuse Donald Trump of about the documents, but he's an old guy and the jury isn't likely to convict him. But then again, 2.5 years difference between him and Donald Trump, that doesn't apply to Donald Trump. See, it's politically motivated. So what winds up happening is we were taught, don't take the case if you can't win it or you don't have a realistic chance of winning it in front of a jury. Nowadays, when you peep into a law school course, what they wind up telling the lawyers is, this case you'll never win at trial, but the embarrassment value is such that you are likely to be able to extort a settlement out of the defendant for the nuisance value of the thing. So now you are encouraging lawsuits that are not winnable lawsuits. It's the embarrassment, it's the extortive aspect of it. And this also goes along with the federal criminal law that Joe Biden, James Eastland, Byrd, former Grand Dragon of the Klan, there's a cabal they had. They introduced legislation that passed 40 years ago so the federal prosecutors can bring cases with no realistic proposition of getting a conviction, but using the pendency of the cases for embarrassment.
One last question on Jay-Z.
I just think it's wrong for these statute of limitations to be changed like this.
Also, what do you, well, I can't ask you, what do you think he should do because you will be giving legal advice, right?
No, I haven't talked to him. That wouldn't be legal advice, but go ahead.
So in this situation, do you think that this would be thrown out? What should the next steps that Jay-Z should do? You know,
well, they're forum shopping and it's in New York City area, New York metropolitan area. So you can't guarantee what's going to happen on the front end. But if you can afford it, I'd say fight it.
yes.
One of the reasons for that is a lot of the lawyers that are filing the lawsuits can't prosecute a trial. They don't know how. I give this example. You walk into a doctor's office that your family physician has referred you to. You see the medical degrees on the wall. And then you find out that the doctor you got referred to has had no experience as either an intern nor a resident. And you start losing confidence. You say, oh, this guy's got book learning, but no hands-on experience. Now, in the law, it used to be in American law that practitioners got the opportunity to work for a government agency, state, local, municipal, or the feds, or you worked for a prosecutor's office or a defender's office or a public interest group, and you got a chance to try cases. And when you're actually dealing with some human being on the other side, or 12 of them or 6 of them having to render the verdict on what you have presented, you get an idea after a while as to what works, much outside of the books. But we have judges who are on a bench who have had absolutely no trial experience as lawyers, let alone as judges. And we get people who get a lot of cases, some semblance of fame for settling them, but having zero to very limited experience when it comes to trying those cases. And then we get stuff like we were looking at with the cabinet position reactions where the FBI threatens to resign en masse if so-and-so is appointed, or the injustice. Well, a lot of times you may have people who have a lot of experience in a subject because they've been there taking the pitches and seeing whether they're balls or strikes, running the bases, seeing how the fly balls look when they're up against the sky or the silhouette of bright sunlight, and getting ideas how the game works. First is those people who just read about it and never played the game, which, by the way, is one reason sometimes there is a weird thing that happens when the feminists start hollering about they want a woman coach of a male ball team, and the female coach and say something like football hasn't had the experience of getting knocked silly or halfway unconscious or really getting hurt by getting hit hard to fall back on when they start trying to inspire the boys. And it's not what's good. So we have amateurs who are doing stuff because they wanted to do it or because they make money, and they're not necessarily qualified. It's like, I want to fly a 737. Well, yeah, but you don't have a pilot's license. So what makes you think we can turn one loose on you, you know, and you can fly a 737? Doesn't work.